I'm talking today to U.S. Attorney Sherrie Abney. Hi, Sherrie. Thank you so much for letting me interview you today for Askimo's International Library of Interviews with Experts.
Hi, Joanne. It's very nice to be with you today. Thank you for inviting
Lovely
me.
to talk to you today too, Sherrie. Sherrie, today we're talking about dispute resolutions and staying out of the courts. So let's start with, how can you discover which clients and disputes are appropriate for out-of-court settlements?
Not all clients, or lawyers for that matter, are appropriate candidates for the collaborative process. Before suggesting the process, the lawyer must conduct a screening interview with the client to determine what dispute resolution procedure best suits that client's situation. There are some disputes that must be addressed in a specific process, such as the administrative agencies of state, local, and federal governments. This would include disputes such as bankruptcy, tax court, public school system, Social Security benefits, and currently there are people in those areas who are working to develop either the collaborative process or a similar interest-based procedure. After you consider jurisdiction, the parties themselves must be considered. If one of the parties is mentally or emotionally ill or suffers from an addiction, if that's the case, that party may not be able to function in the process. But you should always investigate, because to say a flat always that no one can participate is a mistake, because some of the people, in spite of their disability, can. What does the client expect from the dispute resolution process? Many times they really don't know. They just know they have a problem, but you need to talk about this up front. And I like to know, what does the client expect from me, their lawyer? If they want me to do something that I feel is unethical or that should not be done, then that client is not a fit for me. Will the client take responsibility for his or her part in creating the problem? Will the client, and this is even more important, take responsibility for his or her part in resolving the dispute? Is confidentiality important? Is a continuing relationship with the other party or parties important? Is scheduling important? Or can you show up whenever the court happens to put you on their docket? Is time of the essence? Do you not want to wait 2 or 3 years to get this thing over with? Are the parties in the same state or country? Can this person sit in the same room with the other party and be civil and comfortable? Are they capable of listening to the other party and what their views are? Is the client looking for a remedy, or do they just want revenge? These are all things that you really need to know. Once the questions like this have been asked, then the lawyer should explain the various methods of dispute resolution that are available, such as litigation, arbitration, mediation, and the collaborative process. There have been times when I've known that certain people that have come to see me are not candidates for the process, and I have simply told them that I believe that their interests would be best served if they found a good litigation lawyer. But if the person appears to be a good prospect for the process, after I've explained the various choices, I ask them to choose how they would like to proceed. When they've heard all the choices, most of the people opt for the collaborative process. Collaborative lawyers are pretty much required, ethically required, to give this explanation in the United States. However, I don't believe litigation lawyers are required, or they have not been in the habit of giving these same choices to people.
What is the impact of transparency on dispute resolution?
Transparency has many definitions, but the one we're concerned with in the collaborative process deals with openness, truthfulness, and accountability. In the collaborative process, our goal is to build a team. Instead of perceiving the process from an adversarial us and them point of view, all of the parties and the lawyers become us, and the problem becomes them. In other words, we put the problem in the middle of the table and surround and conquer it. To do this, we must become a team. And the only way a successful team can emerge is to build trust between the participants. And trust is built on truth, openness, good communication skills, and accountability. The participants in the process have agreed to abide by standards of civility and truthfulness in the participation agreement. This means that if I have information that has a bearing on the outcome of the dispute, I must deliver it, whether or not it favors or disfavors my client. This holds true for all relevant information, even if the other party has not requested that I give them the information. If I know it exists, I should deliver it. The test to determine whether or not something is relevant is to ask, if I was the other party, would I want to know about this before I settle? If the answer is maybe or yes, then the information must be delivered. Some people are very uncomfortable with this. They tell me that if something is not given under oath and they believe that they can't get the information anyway except under the supervision of the courts. And my response to that is to ask, have you ever heard of anyone lying under oath? And how many times have you heard of attorneys being fined and disciplined for spoliation of evidence? At least in the collaborative process, you are face to face with the other parties. You have a much better chance of determining whether or not they are acting honestly and in good faith than you have when they're hiding behind procedures used in formal discovery.
Talk to me briefly about the paradigm shift from adversarial bargaining to interest-based negotiations.
For lawyers, this is 180 degree about face. In litigation, some lawyers attempt to intimidate the other parties to gain an advantage. In the collaborative process, each lawyer only represents his or her client and no one else. But each lawyer must take the other party's interest into consideration if they expect to get an agreed settlement. In order to accomplish this, collaborative lawyers want the other parties to be comfortable with them so they can understand all sides of the dispute, and the other parties will share information with them about their feelings concerning the dispute. Lawyers also want to form a good working relationship with the other lawyers in order to develop ideas to help their clients. In terms of the clients, the lawyers want them to focus not on blame, but the interest of all the parties. My client can call the other party a liar, which will likely make him angry and result in him defending himself. On the other hand, my client could say, I could not believe what you told me. This calls for an explanation rather than a defense. Since the speaker is the only one that truly knows what she believes or how she feels, no one can argue with the truth of that statement. He can only tell her why she should not believe he lied. Speaking in the first person about what a person believes and feels allows that person to state his or her interest in a non-adversarial way and to solicit information from the other parties rather than escalate conflict with accusations that may or may not be true.
Finally, what should we know about making litigation the alternative form of dispute resolution?
A lot of lawyers in Dallas have joked with me about litigation being the alternative. They don't see it happening. I believe it will happen someday. Lawyers have never been very popular folks. Shakespeare said, let's kill all the lawyers. Dickens' worst villains were lawyers. The Bible admonishes people to settle differences before they get in front of the judge. And even people acquainted with the legal system here in the United States have warned about legal battles. Lincoln said, discourage litigation, persuade your neighbors to compromise whenever you can. Former U.S. Supreme Court Justice Sandra Day O'Connor stated the courts of this country should not be the places where resolution begins, They should be the places where disputes end after alternative methods have been tried and have failed. Many people much wiser than I have admonished people to look to litigation as the alternative and last resort to dispute resolution. Lincoln also said, force is all-conquering, but victories are short-lived. When parties rely on the courts, the decision for at least one side comes by force. And there have been times that both sides have appealed the judge's decisions. In addition, when the problem is an ongoing one, the interests of everyone concerned are not always taken into consideration. It's very likely the problem will recur and the parties will find themselves back at the courthouse. When parties play a part in creating their solution, they are more willing to carry out the terms. And they've also constructed a model that if they have another dispute, they can follow it.
Thank you, Sherrie. Thank you so much for talking to me today.
You're very welcome.